Hey folks, Dave Ceruolo, real estate probate and elder law attorney. In this video, we're going to go back and look at some of the comparisons that I made with estate planning documents to try and bring out the differences and the similarities between them or among them. Now, if you're watching me on Facebook, make sure that you like the video. If you're watching me on YouTube, make sure you click the lower right-hand corner to subscribe. Stay tuned. So what's the difference between a last will and testament and a trust? Well, folks, first of all, the last will and testament. This is a written legal document that disposes of the assets of the maker at the time of their passing. And in general, the will must be in writing. The person who's signing it must be competent, must understand what they're signing, and be above the age of majority. And the will must be witnessed by two disinterested parties. Parties that are not involved in the estate or named in the will. Now, the will is going to designate a manager of the estate called a personal representative. That person used to be called an executor of the estate. That's been changed in Massachusetts. And it's also going to designate people to take from the estate, called devisees or heirs to the estate. Now, if there are minor children involved, then guardians for those children can be appointed through the will, as well as assets can be held in trust for the benefit of those children until they reach the age of majority or an age that the maker designates through the will. Now, flashing forward to the trust. The trust is, once again, a legal written document, and it holds assets for the benefit of others. Now, the maker of the trust, called the donor or the grantor, all the same person, can appoint a manager of the trust, and that manager is called the trustee. And also the trust will name beneficiaries, people who are going to take the assets from the trust. Now, this trust can be formed while the maker is alive and can go into effect while the maker is alive. As a matter of fact, most trusts are funded while the maker is alive. By funding, that means assets have to be transferred into the trust to be held. Whether it's money or real estate, the trust can hold those things, and the trustee will act as the manager for those assets while the trust is in effect. When the maker passes away, the trust can have a provision in there that says that the assets will then be given to the beneficiaries. And it can be structured like the maker's will, but the difference between the documents is you don't need court involvement, and it can be funded during the maker's lifetime, and it actually can operate during the maker's lifetime. So the difference between the documents are that you need the probate court for the will, and it only comes into effect when the maker passes away. The trust, on the other hand, is a legal document that will hold assets during the maker's lifetime. And you don't need the court's involvement in general to administer or to divide the assets of the maker. Dave Ceruolo, CeruoloLaw.com. What's the difference between a limited power of attorney and a durable power of attorney? Well, folks, first of all, we have to understand what a power of attorney is. This is a written legal authorization that allows an agent to act on behalf of the maker with respect to their investments. And so the document itself will appoint the agent, called an attorney in fact, to handle the assets of the maker. Could be their money, could be their investments, could be their real estate. Now, when you have a limited power of attorney, that just means that a document is limited in scope with respect to the power and the time that it's in existence. So what can happen is the maker can appoint a limited attorney in fact to help them with the sale of a piece of real estate or help them to manage a particular asset. And then once that management job is done, the limited power of attorney in general will go away. Now, with a durable power of attorney, this once again will appoint the agent, called the attorney in fact, and the durable power of attorney will be general in scope with respect to the power, and the power will exist for as long as the maker is alive. And so this document will go into effect, and the agent will be able to step into the shoes of the maker right away and handle any asset that the maker has. Could be real estate, could be their bank accounts, could be their investments, could be business options and stock. It could be representation in front of the court or representation before Medicaid. A lot of powers are specified in this durable power, and the power itself will exist. So if the maker for some reason becomes incompetent or sick and is still alive, that power will remain in effect, and it will allow the agent to act on behalf of the maker with respect to their assets. Now, so this is the difference between a limited power of attorney and a durable power of attorney. And both documents are very effective, but one is short in time and short in scope. The other is longer for the duration of the maker's lifetime and general in scope with respect to the powers, right? Dave Ceruolo, CeruoloLaw.com. What's the difference between a healthcare proxy, a living will, and a DNR, or do not resuscitate? Well, folks, first of all of these types of documents fall under the term advance directive. And what the term advance directive means is it's an advance direction that you're giving your medical professionals or your medical agent to do or not do something for you should you be in a state where you're not able to make your decisions. Now, when it comes to a healthcare proxy, this is sometimes called a power of attorney for healthcare in some states. With this document, it's a legal written document in which you're creating an agency, and your agent will step into your shoes and make decisions for you medically should you be unable to do so. Now, what happens when the agent steps into your shoes is they're supposed to act reasonably, listen to the prognosis of the doctors, and then allow administration of assistance to you, medical assistance to you, based upon the prognosis. Now, when you become better, then the agency goes away and your decisions rule unless it's decided or it's determined that you are not competent to make your own decisions. Now, when it comes to a living will, this once again falls under the term of an advance directive, but in a living will, what you're saying is that is if you're in a state where you need assistance from a life support machine and your prognosis is bleak, that you're never coming out of that condition that you're in, you're telling your agent to take you off of the life support mechanism or life support machine. It's a little bit different from the healthcare proxy, and it's also a little bit different from the DNR, the do not resuscitate. Now, with a DNR, this is an order, and you usually need the assistance of a medical professional to put it in place. But it's an order where you're telling folks that you do not want to be brought back should you stop breathing. In other words, you don't want CPR or any administration that's going to help you begin breathing again should you stop breathing. So this is a little bit different from the living will, which talks about life support. So the difference between these three documents, you have one which is creating, well, they're all basically creating some type of an agency, right? But you have one that's creating an agency, and your agent is going to make your decisions medically for you should you not be able to do so. The second is the living will, and that's basically saying if you're in a state where you need life support and you're never coming out of it, you don't want to be, you basically don't want to live that way. And then with the DNR, you don't want CPR. You don't want to be brought back should you stop breathing. That's the way all of these documents differ, and they all fall under the same term of advance directive. Dave Ceruolo, CeruoloLaw.com.